and gentlemen, I am officially running for President of the United States. And
Good morning, good evening, good afternoon. Hope everyone is doing well on this lovely Monday afternoon, evening for some. I'm here with the lovely Chandler. Hello.
Hello, hello. Hi.
And we're going to be going over the last day of, there might be a couple random videos, but this is going to be the last day of Latunski. So, I didn't want to spoil the surprise, but yeah, we should be able to get through it all tonight and be reasonably finished soon. He kind of did confess to detectives for 4 hours. There wasn't much there, so but there's some interesting stuff, some family impact statements, sentencing, all that kind of stuff. So yeah, we'll say hello to everyone and jump right in it. If you have not subscribed yet, what the hell are you doing? I'm 33 away, y'all. 30.
He's so close. Subscribe, damn it. Help this guy get monetized.
So close.
So you have, I have the subscribers, but not the watch hours. You have the watch hours, but not the subscribers. We've got to get all of your ducks in a row.
Oh. Excuse me, 18. Sorry.
Ooh.
YouTube's being a fucker today, by the way.
Hey, 18.
Yeah.
I guess that plug that I gave you on Vices maybe got you a couple more.
Yeah.
I tried.
Yeah. No, I appreciate it. I truly do. Every little bit helps, and I'm getting there. So we're 18. We'll see where it goes from there. So, but I'm so close. Damn, I'm so close.
That's what she said.
So let's say hello to the lovely Impish. Hello. Scad, what's up? What?
I am. I have X chromosomes. Why do you ask?
Girl means guy in real life. So girls on the internet don't exist.
Oh, okay. Don't know what to tell you. Here I am on the internet, a woman. Can't help it.
Yeah. What's up, Dazzer? You know better than to ask that. That's never gonna happen.
The answer is no.
What's up? What's up, Big John Fuck? Sleazy.
I have a bolognese on the way that I have ordered for delivery, so yes, I am hungry.
What's up, Dees?
Oh, am I supposed to be saying hi too? Hi, everybody.
No, you don't have to. Sorry, I was reading ahead.
I'm like, I don't know all of you, but you seem cool based on your words and pictures. So,
they're awesome.
I'm sure they're great.
I'm so excited for tonight. I told Meaty the other day we should make Murder Mondays with Meaty. I mean, that's essentially what it probably is going to boil down to.
I mean, white women love it. You could get a whole new audience.
Yeah, I'm always looking for a new audience. Just to get to 1,000.
Expand your demographics, my friend.
Yeah. I wonder if bacon's nipples taste like pepperoni. I don't know. What's up, AP?
I think pepperoni has seasonings and they're cured, and I kind of doubt that somehow.
Oh, he brought the seasoning though when he cooked the balls. Remember?
I thought you said that he didn't season them.
I think he said he went minimal with salt and pepper, right?
Salt and pepper is not seasoning.
Oh yeah, we had this argument before.
It's just not. I mean, throw a little garlic in there at least. My God, do some Italian somethings. Yeah, oregano. Some rosemary. Something. Salt and
Yeah.
pepper? No, I'm sorry. It doesn't work.
He needs a deeper palate for more than just balls.
Well, yeah.
Barb, hello. I think he did
Barbara?
actually intend on seasoning the jerky he was going to make out of them. So,
Well, you gotta season jerky. I mean, that's essential.
right.
But he didn't get to that point, did he? Because he was arrested. Because he bought a dehydrator, right? Wasn't that the thing?
Yep.
That's so sad. I wonder how. I really want to know what his recipe for jerky would have been.
Yeah, that would have been interesting to. I swear he should do a cookbook, but
Well, maybe if you meet him, you'll get to ask him for his recipes. That'll be an opportunity that you can seize.
oh hell yeah, I certainly will. So, that's exactly what it is. So I can get myself abruptly demonetized. I just want to hit that 1,000. After that, I don't give a shit. So
That's actually a very good point, Sean. I'm like, how long are you going to last? Because here's the thing: you have to apply for monetization, right? And that means they have to go over all your videos and review the content. So we'll see if that actually goes forward.
I mean, I haven't gotten any strikes or community guidelines or anything. So yeah,
Well,
just saying.
it's it'll be an adventure. If you get monetized, then I'll feel more confident because I've said a couple of naughty words here and there on my streams and videos, and I'm like, oh no, I called it domestic violence instead of DV. Does that mean that I'm not going to get monetized? Because I don't know how YouTube works. I'm brand new to all of this, so we will see. We'll see.
Yeah, it's more. I mean, even if they don't, I'm not going to be upset about it. I mean, it's more of the I got there than anything else. So.
That's fair. I'm kind of the same way. I'm just like, this is really fun and everything, but like, YouTube's not gonna be my, what's it called?
Long-term career.
I mean, YouTube is for fun. YouTube
Right.
is for making friends and, learning from people, and it's not gonna be my what's that thing that where you make money for your life something.
Like, I don't know.
That thing. It's not going to be my career, basically.
Oh, okay.
Sorry, it's been a lot. I've been working since 5, and my brain is fried.
Oh, I know. You've been on with Jeff all freaking day.
I have.
That was a rough.
I've been like streaming and working kind of intermittently, and it's just been. I got up super early, so. But you know what? It's been a productive day, so I feel very satisfied with that.
Good deal. Good deal. Mystic, hello.
Hello.
Yeah, I did put on my hat, even without you even asked. So, my tinfoil hat. I hear oysters. What the fuck? It started weird. When isn't it weird?
Is it supposed to be weird?
It's supposed to be a little weird, yeah. Fuck you, Dazzler. Light Rain, hello. What's up, Fast Group? It's been a minute. Hope you're doing well. Chicken thighs tonight? Oh, do we got a treat for you? Literally.
Competition chicken thighs. Thigh versus thigh. I like it.
Hey, what's up, Jude? Good to see you.
Hey, Jude.
What
Sorry.
the hell? God, I hope so. I get hope so. Yeah. You thought the Crowder apocalypse was bad. Shit. Like, I'm gonna blow him out of the water. 84. Latunski raised beef cattle to show competitions as a child. Damn. I didn't know that.
That's rather interesting.
Yeah, I mean, 2-3 hours. If it's longer than that, somebody's asleep. So. Oh, there's nothing wrong with a good atom bomb. Like, yeah, it's a practice run. I mean, either way. Yep. I rarely do. Like, mod is like it's like one of those honorary titles. I don't actually do shit, but it's like an honorary title. So, without further ado, we said hi to everybody. Oh shit, Rumble. But nobody ever chats on Rumble, so Impish, hello over on Rumble. I'm almost at 300 on Rumble, which is pretty nice too.
Nice. I still have not figured out how the hell Rumble works or what I'm going to do with it. It probably could be a good platform for me at some point, but it confuses me.
The interface could be a hell of a lot better.
It leaves something to be desired, that's for sure.
Let's get it. We're getting there. 16 now, buddy.
About this.
Hell
if I tweeted about it, then maybe I could get 18 people. I mean, I have enough followers on Twitter to maybe bring you at least a couple new people.
I would appreciate that. Yeah.
Oh, absolutely.
He'll be there in a few minutes.
Hey. I hope your kid feels better. Oof. Hayden joined us late for the Travis Rudolph trial.
Oh, I saw him on there for a minute, but yeah, you always do, buddy. There it is. It's ass. What's ass? Anyways, I don't know what the hell Brian's talking about.
That's a mysterious comment.
We just nod and say, okay, to Brian.
Well, I always like coming on stream with you because it means I can turn my camera off. I'm literally in bed right now. I just kind of need to be. I'm just like, I'm done for the moment. I need to chill. So this is like very low key.
Yeah, I'm much more laid back than the serious trial people. Like fucking Ozzy, who I love dearly.
I mean, I'm incredibly high-strung, but I enjoy being not high-strung for moments of time, so...
He did make me... Oh, it's ass. Rumble is ass. Gotcha.
You need to be more specific.
He did make me wear a tie when the one time I came on stream and turned on the camera, so... Fucker. That's true. Light rain's onto something there, but, you know...
I'm fully clothed, but, you know.
It's that kind of day. And we'll go to the bed. Yeah. Fucking tired, but we'll make it through. So, this is the Shiawassee County Courthouse. It is in Corona, Michigan. And
Sure. I'm sure that's a real place. I've never heard of it, but I will take your word for it.
100%. Corunna. Michigan.
Okay, you spelled it. I believe that's a real place.
Yeah. So, ever, never wear pants.
I mean, that's just smart.
You know I'll do anything for you, Ozman.
Well, Hayden's awesome.
Hayden is a real one. He's my favorite. So, anyways, wait, who? What? Exactly.
Pants are prison. That's true. Flux definitely says pants are prison, and I agree with her. Bras are prison. You don't ever have to worry about that, but I do, unfortunately. Bras are prison. And this guy, Mark Latunski, yes, he was definitely accused of cannibalism, was he not? Are you asking about Mark? Yeah. Is that person confused? Because, I mean, it's the cannibalism trial, so I feel like it's kind of in the name.
Yeah.
We've seen a lot. We've heard a lot. that we can't unsee or unhear. Oh wow, was my tweet that popular?
I don't know, but we'll make it work.
No.
I don't even wear that. I just
No,
let
but
it all
Latunski
hang out.
does. He has a leather kilt. He has a cargo kilt that's like a khaki cargo kilt. I love that.
He is, yeah.
He's
I
a
will.
fashionable guy, and it's sad that he's going to be in prison because he's not going to be able to, like, you know, put on his cute little outfits anymore, and he's going to have to wear pants. It's going to be really awful for him. I mean, that's been his reality, and it's just like, I feel like he just has this sausage imprisonment situation that exactly, like, he's not going to be able to have the wang out. It's very, very sad. I clearly liked flapping in the breeze. I feel sorry for him.
Hang out with your wang out, yeah. I mean, he's in prison, so what the fuck are they gonna do? Make him wear, like, tape the pants on? So. Oh.
What if
Yep,
he refused to wear pants in prison? What could they do?
That's what I'm saying. Tape them on, maybe? But is that cruel and unusual? I don't know.
I don't think it's cruel or unusual, but I mean, considering how opposed he seemed to pants, it might be.
Yeah. I mean, maybe he can make his own out of the prison pants.
Quite possibly.
God damn it! I was gonna try and wait for 1K, but
Do you have another guest?
no, I'm trying to wait for 1,000. We're at 998.
Oh, before we start?
Yeah, but we'll start, and I'll just immediately interrupt when it happens.
That also
So
sounds
okay.
good. I could go with that. Yeah. Your call, my friend.
All right, we'll start this. So
Will be arguing on behalf of the people.
I will be, Your Honor.
All right, Mr. Leach.
Thank you, Your Honor. With regard to the defendant's argument or
that probably
motion,
sucks.
I would
Volume-wise.
ask that at least in part, that the
a bit low.
court deny defendant's motion. I don't think there's much dispute that the defendant does not suffer from an intellectual disability. There have been experts from the defendant's forensic center, independent expert, both of whom have prepared reports, and
Oh shit! Hang on. Let me.
Got a little audio doubling here.
Yeah, I'm gonna try and. I mean, we're waiting for 2 more. That's what I meant. Totally what I meant is we're waiting for 2 more. Not installing a volume booster again.
Well, while you're doing that, I'm going to look up cannibalism statutes in, where is this, Ohio?
Michigan.
Oh, it's Michigan. Okay. Thank you for telling me that. Otherwise,
Yeah,
I would
no
have been
worries.
looking in totally the wrong state. Because I have access to LexisNexis again. Because do you know what that is?
Yeah, it's like the web dictionary, essentially, I guess. Ish. Right?
No.
Law. Never mind. You know what I mean. Law. It's like the law encyclopedia, I guess. If I can ever
close.
talk. But, okay.
That's a pretty good guess. So it's basically it's a catalog of all of the statutes and jury instructions and case law that one might find in a law library, but digitized.
Okay.
And so I got a new job this week, and I now have access to a LexisNexis, and so I can look up things that are pertinent to these cases, which is really fun. It's something I wasn't able to do before because it's extremely expensive. It's really expensive for law firms to have it. I mean, they have to pay like thousands of dollars a month, something like that, for either LexisNexis, which I was not trained to use, or Westlaw, which I am certified in. But it's pretty much the same thing. It's just slightly different interface.
Okay.
And this morning I was able to use it when we were doing the Florida trial, and I was able to look up the stand your ground laws and statutes for the Castle Doctrine as pertained to the, the NFL player case that we were covering. So that was fun. And so now I can go look up cannibal statutes in Michigan.
That's fantastic. That's a good use of the time.
The only problem is my boss might see that I looked it up, but I don't think that he will mind necessarily. I will tell him that it was for a research project, and well, he's a streamer, so he gets it.
Yeah.
Let's see.
This guy's nuts. I worked with Kevin Bacon, so this is crazy. Yeah, this. We watched his interrogation, watched the other two 911 calls, and now we're finishing up with the kind of the trial witness statements, that kind of stuff. This guy is fruity as all hell. Like, he is nuts. So sorry to hear about Kevin, but yeah, this guy has been absolutely insane the entire time. And welcome to the channel. That's what I'm saying.
Well, it sounds like an encyclopedia, but it's not exactly the same thing as an encyclopedia because an encyclopedia, I would say, has lots of definitions of things. It's not so much about legal definitions as it is about, statutes and the like.
Gotcha.
So, I mean, it depends on how. I actually don't really know if the definition of the word encyclopedia encompasses it. I just know that the way that I think of an encyclopedia, it's a little different.
Gotcha. Holy shit, we're 1K. 1K.
Oh, yeah?
Oh, fuck yeah.
Oh, hell
1K.
motherfucking yes. Congratulations!
Thank you, everyone. Holy shit.
This is an epic moment. I'm so happy to be here for this. That's awesome.
That is awesome. Thank you. Thank you to everybody that's helped me get here. Ozzy, Impish, Bell, all the other streamers, Chandler, Brian. So many people.
I did
Thank
nothing,
you.
but you are welcome.
You hung out with me.
That's
that
true.
counts.
I did
So.
hang out with you. I can take credit for that for sure.
Yeah.
Congratulations!
Holy
this is so
shit.
exciting.
Whoa. Now there's 1001. Let's
Slow
let's
your
go
roll,
back a
people.
little bit.
Chill.
Jesus.
Slow down. That's epic.
So. Wow. Damn. Like.
It's a good
Holy
feeling.
shit. Like, I've been trying to get here for so long, and, like, now I'm here. Holy hell. Okay.
Take it in. Absorb it.
I am.
Let me
That's
see.
so awesome.
Take a moment to enjoy your win. I need to grab my charger.
Okay. Thank you so much, people. Like, that's so awesome. Wow. I finally made it. That's cool. And I appreciate everyone that's helped me get here. It wouldn't have got this way if it wasn't for everybody that's been around me, for real. So damn, that's really cool. Now I have to figure out how to apply for monetization so I can get demonetized at some point. Wow, that's awesome. Aw, you're such a sweetheart. My wife said it for you. Bullshit. I said I want to get to 1,000 and then I'm good. So, what's up, Rose? Thank you, Linda. Exactly, Desert. Scad, thank you. Light Rain, thank you. Oh shit! No, don't do that. Don't do that. I'm good. Although I would taste it just because you're always such a bitch about it. Like, I think it would be kind of cool to just to show you up just one time. So, yeah, damn, that's crazy. I have no idea. Okay, so I'll figure that out later. Let's have a stream at some point. I mean, I would. Thank you. I appreciate it. I tend to talk about the stuff that other people won't or or can't or are afraid to. So, wait, you agreed with AP? What the hell did AP say? No, hell no. I wanted to get to 1 and then I was good. Yeah, I know. Are you offering your balls, JS? Thunder, fuck, what? It's Thunderstruck. Wait, what?
I've returned.
Okay, well, they're plotting. Hang on. Oh, shit.
You need to drink what entire bottle?
A Lord. That's
Getting
true.
paid for that, or you just celebrating?
I won't ever change anything. YouTube can still suck my dick. I'm gonna say what I want and do what I want and talk about the things that may be a little uncomfortable. And that's how I started. That's how I intend to go, and nothing will change. Fuck YouTube. Still. Anyways. I appreciate it, friend. Oh, this is so awesome. All right. Oh yeah, that's right. There's a law against malort in Michigan. You can't do it. We don't allow Illinois in here.
I'm not sure I know what malort is. Sorry.
It
What is
it's Brian, what is malort? Explain it. I'll try that shit up to you.
Oh,
Well,
actually,
Now
wanna know-
maybe.
a fun fact, to interrupt, there are actually no laws against cannibalism per se in the U.S.
Oh, really?
Really? Yeah, there. When I looked it up, it didn't really come up. And so I decided to just Google it instead because that's probably a better use of my search abilities. I mean, of course, the cannibalism part isn't the illegal part. It's the other stuff. It's the stuff that gets you to the cannibalism part, the murder part.
Gotcha. Okay. And so send me some of them, or send me the channel. I forgot, but yeah, we can wind down after. But it's a wormwood-based spirit marketed as digestive. People say it tastes like sewage mixed with gasoline.
Wait, is it actually military special tequila, or is that?
No, that's something different. JST's trying to get me other
Okay,
terrible shit to drink.
I have to just now I have to use my Googling skills and also Google malort.
We'll show you some videos of
Okay.
if Ozzy ever gets it to me. He probably already sent it to me. What the hell am I talking about?
Wormwood
Well, this stream's
isn't that like,
fucking derailed.
What's it called? Wormwood is in absinthe, isn't it?
I don't know.
Yes.
Yes?
Yes.
Okay.
It is. It sounds terrible. I'm curious about it though.
It's horrific.
It's
Two
Swedish.
shots made.
Oh, Nicholas would know about it.
Maybe. Yeah.
Well, he's
Two shots
Swedish.
made Brian puke. On camera. I saw it with my own eyes.
Well, I don't know
We're
who
gonna-
Brian is, but I'm
I think you met Brian.
Have I? Wait, oh, Brian. Oh, was he on your last stream?
Yeah. Black guy?
Yeah. Yes, that guy.
Yep.
Oh, the guy he was black supposedly, but I didn't really see him on camera, so it was just like based on the avatar of him that I had to presume that he was.
Yeah, we all think he's kind of Mexican, but,
Oh.
you know.
Okay. Well, whatever
He's
that
something.
means.
He's something.
I,
Puerto Rican. There you go.
I can't enjoy this trial without I got a bolognese, so I am enjoying that. But I'm trying to open it, and it's very frustrating. It's been a long day. So what is it that we are watching precisely? Are we watching something about Malort? Is it or are we doing Latunski?
I guess we're watching the Malort now, because
Alright.
it brought up, and then we'll go to Mark.
That's okay. I can,
But-
I'm down for whatever.
Celebration Malort. We'll get to it. I promise.
Prescott Van Meyer III, Sommelier from Home, another episode in our series of Malort Mixology. We are today making a Manhattan. Instead of using rye, we're using Malort.
Hey, what's up, Jess?
As usual, that's what we do in this series. So Manhattan normally is rye whiskey with some sweet vermouth, Angostura bitters, some cherry, usually some garnish, either orange. Yeah, have that ready to go.
Had a Japanese
rye
Manhattan
whiskey
the other night at a bar.
New Malort.
It's okay.
And we got all these other flavors to put in there to hopefully maybe mask the smell of that very large animal that died in the drywall. And you need to get it out, but you're not sure where it is. So you just got to smell it for weeks. We're going to put that in a glass. And I'm going to drink it.
It's very like Tim and Eric, I feel.
I normally say this at the end of the episode, but I'm not always in the right state of mind after this series. So make sure to like, comment, and subscribe, and turn on notifications so that you know when a new video pops up. You want to see me drinking a Malort cocktail. That's what you get. Okay. Manhattan, but with Malort, so it's a sad Hatton. A clinically depressed Hatton. All right, doing the classic Manhattan, but I'm going to do it on ice before I strain. All right, 2 ounces of rye. Since then, we'll be using Malort. 1 ounce of sweet vermouth. It says 2 dashes of bitters, just 2. I already know there's extreme bitters from the Malort, so maybe the Angostura will cancel it out, you know, like amplified sound waves, canceling each other out.
It's so funny with his hatred of this,
And
but
these are
he
quite
lost a
literally
bet
the best
someplace.
cherries on the planet,
I'm sure.
And I am
Oh,
so
clearly.
sorry what I'm about to do. Kind of looking like a Bloody Mary. So let's give it a sip. Just see what happens. Ah. That many bitters was the right choice. They really are duking it out.
He's really avoiding drinking it.
Soda is
Oh yeah, it's terrible.
bit, which I appreciate. This is not the worst thing ever. There's a lot of flavors going on with that one. Wow. That's powerful. That's demonic. That is like a very powerful demon that has cursed you to the 3rd and the 4th generation.
Demonic. It's an excellent description.
And Malort has got a hell of an uppercut, doesn't he? But you know what Angostura does? The Johnny Hollywood split punch in the taint. The problem is that Malort really likes getting punched in the taint. I used to think that the pudendum was the area between your genitals and your anus. But I think the pudendum is in your throat. I also didn't know what a chode was for a very long time. But I imagine this is what a chode tastes like. Who's laughing now, Chadwick? I'm not totally sure I understood that reference, but I said it. Chadwick's my brother. If you want to know more, watch the other episodes. I talk about him. Still owe him money. This may or may not be his property.
Hey, Mich, pause this for a second, buddy.
Difficulty focusing right now.
Oh no, what?
So I'm gonna do for you. Congratulations, mini Malort sewer bomb for you. Congratulations on your 1,000 here, buddy.
Oh, you're just going for it, huh?
Oh, it's gonna be fucking awful. But you know, congratulations. I promised you this ages ago.
Thank you, brother.
Ugh.
Oh, what the fuck am I doing?
Oh, it's awful. Oh, fuck. Okay, so
You're
here's a small
celebrating. That's what you're
description.
doing.
It's as bitter as a regular shot is, but the flavor of this isn't actually Guinness, it's a milk stout instead. So it's not truly
Thank
Guinness, but it's pretty close. And because of the milk, it actually tastes like it curdled a little bit. So it was almost worse. So congratulations, buddy. I really appreciate you having me on and all this stuff, and congratulations again.
I appreciate it,
I'm
man.
gonna get off because that was terrible.
Well, thank you for that, Brian. That was
Thanks, buddy.
something.
Bye.
Hey, a promise is a promise, I guess.
Yeah. Brian's a good guy. Even after I doxed him hardcore, he still shows up. Like that's some friendship right there.
Aw, that's so sweet.
So God damn it. There we go. Okay. So that was a real life Malort. And stop. Now I'm all there we go. So we'll watch this guy suffer, and then
All
we'll
I
go back
can
to Mark.
B right now is taste buds. That's
Oh, he's
right.
going to
Taste buds
Chuck.
that are going through a
He's
very
gonna puke.
traumatic experience. If taste buds were a punching bag, Malort would be giving me the old rope-a-dope, the old shoe shine. Just like Rocky, who's from Manhattan, as we all know. No, he's from Philadelphia. My brain is mush. I guess the only thing I can do is to try to eat the cherry.
Oh,
Oh, God help him. Oh, God. Oh, no. Oh, no. What
This
is that
feels like
color?
just
My
a
God.
morass of OSHA violations. I don't know how, but I feel like I've literally broken every single guideline that OSHA recommends. Sorry, OSHA. I am sorry.
it's weird
My
how
mouth
life
is a
works out
danger
like
zone, so if you get near it, wear a hazmat suit. It's
That's
not
on
the good
theme.
Kenny Loggins kind of danger zone. No, you want to get on the highway to that one, away from this danger zone.
that.
Ooh, life sometimes sucks. Anyways, like, share, comment, and subscribe, and turn on your notifications.
All right, so that guy went through the same thing that Brian just went through.
So the moral of the story is don't hate the player, don't hate the game, hate yourself. You
Yes.
set this whole thing up. You fucked yourself, bro.
Yeah, Castro. Brian came on to drink his Malort, Chicago car bomb, sewer bomb, whatever the hell they call them. And yeah, so we still haven't got started because we got so sidetracked because I finally hit 1K. So, all right. So real talk, we're gonna get into this at this point. Thank you, everyone, once again.
Congratulations. Everything nauseating. Put it all in.
Yeah, fuck it. We'll just roll into the next one. So yeah, back to this. Hopefully the volume booster worked.
Will be arguing on behalf of the people.
Doesn't sound like
I will be
it. Does it?
All right, Mr. Leach.
Thank you, Honor. With regard to the defendant's argument or motion, we would ask that at least in part, that the court deny defendant's motion. I don't think there's much dispute that the defendant does not suffer from an intellectual disability. There have been
So, shit. This is on Facebook because it was through Zoom. But so this is the pretrial stuff. So, god damn it. I fucked it all up. Give me 1 second. All right. Damn you, StreamYard.
experts from the
There we go.
forensic center, as independent expert, both of whom have prepared reports, and both neither suggests that the defendant has an intellectual disability. So
Okay,
with regard
so
to that,
I
don't
have.
think-
Damn it. I have an echo and sound issues.
All right, Mr. Leach.
Thank you, Your Honor. With regard to the defendant's
let's see if that
argument
works.
or motion, we would ask that at least
All right,
in
I'm not
part,
touching it.
that the court deny defendant's motion. I don't think there's much dispute that the defendant does not suffer from an intellectual disability. There have been experts from the forensic center, independent expert, both of whom have prepared.
No, that's
reports
definitely their
and
audio.
both reports conforming to the law, and the fact that if the NGRI defense is affirmatively presented as we have been asserted that it is, in that circumstance, there really isn't an argument
Yes.
as to the fact
Oh,
that
I know,
Mr.
professional,
Bacon
right?
was killed by Mr. Latunski. Therefore, that is an example of him not conforming to the law, as killing is against the law, Your Honor. So I think for those reasons, but particularly as it relates to the
I don't want to stop it again.
including of
Hang on.
evidence without a more
So he went through pretrial, and I was going to kind of walk you through, but I'll give you a base overview. He went to pretrial and then was going to go to trial. Then there was an argument that we're going to play of him arguing against, or his attorney arguing against the other two gentlemen testifying against him. And when they decided to testify and identify him, then he pled guilty. So this is kind of that pretrial into the arguments back and forth into, and then it went very quickly into the sentencing and all that kind of stuff. So
specific request as to what actual evidence they're asking
Yep.
us to preclude, I don't believe the court should grant its motion. Thank you.
Thank you, Mr. Leach. Mr. Krause, it's your burden, your motion. You want last call?
I have nothing further, Your Honor. Thank you.
Thank you. And the court's ready to rule. And defendant's motion seeks modification of the pattern jury instruction and to preclude evidence that defendant claims is irrelevant to his insanity defense. The instruction, which is 7.11,
he
provides
also
definitions for both
started
mental illness
representing himself, and
intellectual
quickly the
disability.
judge ruled
As
for a
the
lawyer.
court understands defendant's motion, defendant wants to alter the pattern jury instruction to exclude reference to intellectual disability. The defendant says he does not intend to argue or introduce evidence relating to intellectual disability. However, the court is required to instruct the jury on both mental illness and intellectual disability. That's a directive contained in MCL 768.29A, which also incorporates MCL 768.21A. So the pattern instruction accurately states the law
768.21A.
applicable to this case. The court is, however, willing to consider a modification to the pattern instruction provided. First, that waiver must be conducted on the record. Second, the parties must stipulate
Yeah, no worries, Dad.
modified version
Sorry, I
of the
could have.
instruction. The court will grant the motion subject to those conditions. Otherwise, the motion will be denied and the court will give the pattern instruction. Finally, to the extent the motion seeks to preclude evidence of intellectual disability, the motion only gives that issue cursory treatment, so the court will deny that request accordingly. So that takes care of motion number 1. Moving to motion number 2 is defense motion for a non-standard jury instruction. Mr. Krause.
Thank you, Your Honor.
You're welcome.
I realize this, our motion on this point is rather novel.
Pardon me?
Rather novel. I think it's a novel motion.
Oh, novel.
Yes,
Okay.
and but I submit this case is unique, Your Honor, and with all respect to the prosecutor, for the reasons
Unique is
set
a
forth
word
in our
for it.
brief,
That's
Yeah.
my
true.
opinion is not well reasoned, and
But it's law, though, isn't it?
yes, it is, Your Honor. Yes, it is.
You're asking the circuit court to take a position contrary to the Supreme Court?
Well, I am, Your Honor, and I think
Seriously?
I'll just say that the GOAT opinion has not stood the test of time well,
Oh my God.
Particularly since it's based on logical fallacies. But I certainly understand that this court is required to follow the law. And I appreciate that our argument...
Wait, did he just say, yeah, I would be telling you to go into the Supreme Court, but I don't agree with it, and I think it's stupid, so you should do what I want anyways?
Kind of. I mean, he made some reference to logical fallacies. It sounds like he is committing his own. I think he's trying to imply that there's some logical fallacy within the law. It sounds like.
Okay.
But this is actually really interesting. I want to hear what else he says, because this is a very stupid argument. Also, it looks like this guy took he pled guilty against the advice of his lawyer. So I'm
Yes.
really curious about the attorney in this case.
So he started kind of sob-sit-ish, and he was going to represent himself.
Yeah.
Then the judge appointed counsel, and then, and this is all just small-town court shit, so I couldn't find anything there, but, and then it might have been done through motions, through paper, too. I don't know. But, so then he was going against their advice the entire time, basically, so...
Sure.
Yeah, so it's kind of Brooksish, but not as Brooksish. So, but
argument may only be a step on the path to the Supreme Court's revisiting the Goad ruling.
That's fair.
And I think that because it has not stood the test of time, the Supreme Court should revisit the Goad ruling. And I think it's particularly true in a case like this. And again, I realize that this may be down that road, but I think a step has to be taken somewhere in terms of the court revisiting
Oh, no.
Goad and the factual allegations of this case. An appropriate starting point for that course. And we wanted to preserve that issue, Your Honor. So for the reasons set forth in our brief, we would respectfully ask the court to grant our motion, but I also understand that the court is bound by the law.
All right. Thank you, Mr.
Thank
Krause.
you, Your Honor.
For the people, response?
Thank you, Your Honor. I think Your Honor certainly hit the nail right on the head. The Goad opinion is an opinion by the Supreme Court and should be followed by this court, and we'd ask that for that reason that the motion be denied. Additionally, as stated in our brief, there are lots of reasons to not mention a potential penalty to the jury, and that's exactly what the motion is asking to have happen. So we would ask for those reasons and the reasons set forth by the court that the court deny the defendant's motion in this matter.
Thank you, Mr. Leach. The court will rule on this issue. Defendant seeks to have the court give a non-standard jury instruction. Specifically, he requests that the court read instructions explicitly considered and rejected by People v. Goad. 241-20, that's a 1984 Michigan Supreme Court decision. Goad is very clear in its directive that jurors shall not be given any information concerning disposition of the defendant after their verdict. Defendant today argues that Goad, was wrongly decided. However, that's an issue for the Michigan Supreme Court to consider. In the absence of any showing that Goad is no longer good law, this court lacks authority to disregard Goad's instructions. The motion is therefore denied. The court will give pattern instruction 3.13, which informs jurors that they shall not consider possible penalty when deliberating. That moves us then, Mr. Krause, to your third motion,
Yep.
and that would be to seal photographs.
Oh, his name
Hopefully.
is Kraus, like Lunchbox in the Rittenhouse.
Yeah.
Are going to rely on our motion and brief. On that, I have nothing to offer.
Not a
beyond
typical
that
name.
today, unless the court has questions.
But Mr. Krause, it doesn't appear that any photographs are actually filed with the court.
Quite frankly, Your Honor, I'm not sure about this motion because I did not understand that was up today. And I don't know, those photos are probably the same photos that would be at issue in the motion to exclude
Hey, Dog Mama.
the photographs.
Well, the court's provided with the judge's copy, and there, like I mentioned, there was a flash drive or a USB that had electronic copies of the photographs, but they're just not in the file.
I'm wondering if, I think there may have been an error.
Yep,
on our
rewind it.
office's part in terms of not getting those photos, and I'm wondering if we could ask the court to review
No,
that
that's what I
motion
said.
or review
The volume
motion
sucks, dude.
to exclude the
Um,
photographs.
I turned it up, but I
Well, I'll
volume
leave it to
boosted
you
it,
then,
but
as to your best discretion, how you want to get that in front of the court.
Okay.
May I consider this motion then withdrawn by the defense?
Yes, you can, Your Honor.
Any objection from the people?
No, Your Honor.
Move on to issue number 4. We turn our attention then to the people with their motion of intent to use an independent psychiatric evaluation. Oh, we have Mr. Kerner.
Thank you, Your Honor.
You're welcome.
As we stated in our brief, pursuant to MCL 768.20A3, we are allowed to obtain an independent psychiatric evaluation.
Brian did a
Has
sewer bomb.
attached Dr. Sadov's CV to the notice of intent. He's highly qualified. He's a psychiatrist. Contrary to the defense's assertion that he's already formed an opinion, he's only reviewed Dr. Witherall from the Forensic Center's report and Dr. Mayman's, the defense expert.
You do have that. You have the defense report then?
I do have that, yes. And therefore, we'd ask that he be allowed to complete a thorough analysis by meeting in person with the defendant, other than just reviewing the records. I anticipate if he only reviewed the records, one of the first arguments by the defense at trial said, well, you never saw him. Well, that's because he wouldn't be permitted if the court rules against us. So we'd ask for that.
Thank you, Mr. Kerner. Mr. Kraus.
Lunchbox.
Thank you, Your Honor. Respectfully to the government, there really isn't anything that seems at all independent about the second forensic evaluation the government seeks. They've already indicated that they intend to use its second opinion to rebut the anticipated testimony of Dr. Mayman. So it seems to us the third expert has apparently already reached his opinion. And I do realize the statute allows the court and allows the government to
The statute says exactly that, Mr.
well,
Kraus.
it says it says it may, Your Honor. Our point is simply that it does not seem independent as the statute requires. And
The statute says upon notice of rebutting of the defense of insanity, right?
yes.
When I first read your motion, I thought, your response to the motion, I thought the same thing. I'm like, well, it doesn't seem very independent. And then I pull up the statute and it says to specifically rebut.
Right. And
Poor
but-
choice of wording maybe, but
yes, and
not on
perhaps
your
it
part.
is. Perhaps it is. But our point is, Your Honor, and I will concede that perhaps it's a better left for cross-exam, but it does not seem like a terribly independent examination at this point to us.
Thank you, Mr. Kraus.
Thank
Court will
you.
rule on this issue. The prosecutor seeks leave to obtain an independent psychiatric evaluation to rebut the insanity defense and to have a defendant participate in an interview with their expert. The court notes that the original exam by the forensic center was conducted by a psychologist, while the defense expert and now proposed prosecution expert are both psychiatrists. The defendant argues that the exam is not truly independent because the people indicate that they intend to use this expert's testimony to rebut the insanity defense. Seems like that's true. However, the statute explicitly contemplates that a prosecutor may rely on expert testimony to rebut the insanity defense. Looking to MCL 768.2A sub 7, quote, the prosecuting attorney shall file and serve upon the defendant a notice of rebuttal of the defense of insanity, end quote. Since the statute contemplates that the people may find their own expert to rebut the insanity defense, the court will therefore grant their motion. Which takes us to motion number 5, and that would be the defendant's motion to preclude 404B evidence. There's a little more substance to the notice and the objection and the response, so I thought I'd leave that for last. Counsel ready to proceed on that issue, Mr. Kraus?
Yes, Your Honor.
Okay, very good.
Thank you, and I appreciate the court saving it for last. The government's position
Thank
as
you,
to this
Dogmo.
issue, Your Honor, I think lacks the nuance required to truly analyze the admissibility of the other act's evidence it seeks to introduce in this case.
Can I ask you a question, Mr. Kraus, before
Yes.
you get too far into it? Does the defense intend to advance a theory that Mr. Latunski committed the killing, or does the defense intend to contest the killing?
I don't.
The court would need to, I'm sorry, I would need to know that for the analysis under the 404B.
Oh shit.
We will not be introducing evidence that contests the killing.
That contest the killing.
That's correct.
Okay.
Will not.
All right. Thank you.
At first blush, the other two gentlemen's accounts might seem similar enough under the requisite Vandervliet analysis.
Wait a minute. So 404B, we've heard that before, and thank you, Dog Mama. That's the other acts evidence, correct?
Oh, sorry. I guess I was muted. Yeah, that's prior bad acts.
Okay. So that's the other two gentlemen. So this is where we get into, this was kind of the crux of it. I think he ended up allowing it, but I mean, we'll listen and see. But I thought that reminded me of that, so I just wanted to make sure.
Yeah, of course.
That is because the government is relying upon its own judgmental views and misapprehension of BDSM. Now, while that BDSM may be viewed as an unorthodox sexual practice, it does not include homicide, and it certainly did not include it in the other acts proffered by the government.
Okay.
When looking at each piece of evidence, this court must evaluate the other alleged acts in light of the following standard. The evidence must be relevant under MRE 402, must be offered for a proper purpose under MRE 404B, and the probative value of the evidence must not be substantially outweighed by unfair prejudice. And of course, the government has the burden of proving all these elements. Mr. Latunski is accused of killing the victim with a large knife by stabbing him in the back of the neck and then cutting his throat. He is also accused of removing the victim's testicles after death. But neither of the alleged acts have anything to do with removing body parts, cutting or injuring a person, or anything remotely close to murder. And despite what the government dwells on in its response, this case is not about bondage or fear. It's about allegations of murder and mutilation. And Mr. Bacon's death was not part of any sexual practice, and Mr. Latunski's practice of BDSM with Messrs. Carlson and Palacio absolutely was not indicative of a tendency toward murder or mutilation. Now, despite the government's allegations, there is no evidence of violence or of Mr. Latunski cutting or even threatening
as much as I got, so I turned
to cut the other individuals with a knife. And in People versus Sabin, the Supreme Court held that there must be such concurrence of common features that the various acts are naturally to be explained as caused by a general plan. So there must be some connection between the various acts. And yet that is not the case here. Merely engaging in a sexual practice that includes bondage and discipline, dominance and submission, or sadism and masochism, that some may believe is unorthodox, but one that is not as uncommon as the government wants the court and the jury to believe, and it is absolutely not indicative of a tendency toward murder or mutilation. There is no evidence or even an indication that Mr. Latunski planned on killing either of the other two men. The lack of a concurrence of common features between these consensual acts and the charges here means the alleged other acts cannot be used to show a proper purpose. The government cannot attempt to admit the alleged other acts evidence for propensity purposes by trying to hide it in general language from the rule. There was no common scheme or plan because no knife or other weapon was used in the other alleged acts. There was no blood drawn. There was no violence or injury inflicted on these other individuals. And Mr. Latunski had prior relationships with them, as opposed to the one that was established with Mr. Bacon a day or two before the incident. There simply is no indication of intent or opportunity as proven by the many differences between the incidents. Both of these other acts are glaringly void of any signs of violence, injury, dangerous weapons, and most importantly, murder or mutilation. So from our perspective, Your Honor, the alleged acts are simply too different from the current charges to have any bearing on this trial. And I would note the government chose to ignore the Galloway decision in its response, but there can be no proper purpose of intent or absence of mistake when the other acts do not contain significant similarities to the allegations in this case. And under Galloway, I would submit these other acts should not be admitted. These acts are not relevant to the current charges. There is no intermediate fact linking.
Yes, the guy that he murdered, his name was Kevin Bacon. Kevin Bacon was the name of the individual that he murdered. And all the news articles have it written the same way. It says Bacon didn't show up for breakfast. That's how they knew something was up.
It's curious phrasing. I mean, I feel like they're trying to be funny.
Yeah, I would think so too. But yeah, Kevin Bacon. So interesting name.
6 degrees of separation.
Yep.
The charged and uncharged acts. And the fact that Mr. Latunski engaged in bondage acts with the prior complainants simply does not establish that he had a motive and intent to commit the crime of open murder and mutilation against the current victim. And I would just also note that even if the court were to determine that the
An interesting argument.
other acts are relevant, their prejudicial effect substantially outweighs any probative value. This court, the court must take into account the fact that no charges were ever filed against these other, regarding these other alleged incidents, which is exactly how the complainants wanted it to be at that time. And so where allegations are unproven, the probative value of the evidence is reduced even further. And there is a danger of confusing the jury, we believe, and turning the focus of the trial from the current charges to that of the defendant's alleged prior acts. The inclusion of those separate and distinct incidents in the trial for the current matter would only serve to muddy the waters. The complainant stories from the other alleged acts changed over time, and it was not even until after they were notified by the police that Mr. Latunski was accused of murder that their stories evolved into their current allegations of criminality. So from our standpoint, Your Honor, we believe these allegations would be extremely prejudicial. They directly, negatively impact Mr. Latunski's constitutional right to a fair trial. He's not on trial for those other alleged incidents, and that information has no bearing on the instant matter. So for the reasons set forth in our brief, Your Honor, we respectfully ask that you grant our motion and exclude the other acts evidence proffered by the government.
So before the judge rules, he actually made kind of a damn good argument. No charges filed. They weren't the same, similar, but I don't know. What's your thought on it?
I actually think that he's advocating for his client in a way that is apt. It's not necessarily going to go the distance. I don't know if the judge is going to be into that, but he has to be a zealous advocate for his client, so that's the best thing that he can possibly do, and it's a unique concept that I think pertains to the specificity of the case. So he obviously has put some thought and weight into this. It sounds like it goes contrary to some Supreme Court stuff, so I'm not sure if it's going to get there, but he's doing his best.
Yeah, I won't wreck the info, but yeah, prior bad acts is basically, and those calls were absolutely horrific. Those other men were devastated by what took place. So, but interesting, never any charges were pressed, so, or even brought up. So,
I don't think it's that interesting. I think it makes a lot of sense that the charges were not pressed, considering that I don't think that these guys, maybe they were closeted and they're in this situation where like they were caught in some dude's basement. It's like pressing charges would require them to go through a whole rigmarole where they would expose their proclivities, to people they knew, and it just probably wasn't worth it to them.
Gotcha. That makes sense. Okay.
Which is why it's easy to it's probably easy for a guy like this to take advantage of people. And think about Jeffrey Dahmer, like
right.
Think about all of the closeted kids that, in the 80s that went to that gay bar that he, would pick them up at. Like, it's just, there's that shame, and that secrecy. And I know that it's different now, but it's just like a lot of people live secret lives where people don't really know. what they get into. And this is some BDSM stuff, like, you know, if they were into that, it's like they don't want people knowing about that. They don't want to expose themselves any further. They're just going to forget about it and move on.
Yeah, that's true. Okay.
So it's easy to victimize people like that because he knows that the shame and the secrecy is going to, you know, keep them from squealing.
Yeah.
That's why he did it multiple times. He was able to, and you know how he's like, I've never done anything like this before. This is my first time. Bullshit. Like, he's such a liar. You know, he
Right.
totally had done it before multiple times. So it's like, come on, dude. Like, you knew what you were doing. He totally knew what he was doing. And he took advantage of that.
Absolutely. And
Kind of twisted.
have a victim that really has no recourse. So, he murdered and ate this, and ate this guy's nut. Do you think they didn't press charges because they were closeted? Do you think that? I don't understand that at all, Scat. Am I?
I'm not sure about the connection between the first and the second sentences. It is true that he murdered this guy and he ate one of his testicles. The second sentence, do you think that they didn't press charges because they were closeted? Yeah, probably. Or I mean, maybe they were, you know, somewhat out to some people, but maybe they weren't ready for their whole family to go through that. I don't know.
Let me kind of give some more credence to what Chandler's saying there. You have to take into account this area. We're in rural Michigan, very red, very conservative district, where they're still very singular focused. They're racist as fuck.
Yeah.
And you know,
That's
they're bigoted towards everybody. So was the cannibalism sexual? I think so.
I don't understand that question either. I mean, I think it started with a sex act, it turned into a murder, and then I don't know if the act itself had a sexual component. If it was like an erotic thing for him, it could have been. Clearly, he fantasized about it. I think that this was the first guy that he ate, so if he got off on it, I don't know if he really talked about that, and I don't know if I want to know personally. But you know,
okay, close your ears then. He had sex with the corpse, so we know that from his admission. So.
But that's not the same as, you know, having the cooking and eating of somebody like turn you on.
That's true. Yeah,
I think that's the question that Jacob is asking. Was the cannibalism sexual? Like, I don't really know. Oh, am I too loud?
That's what Beer says. I turned mine way down just so people could turn up their volumes with the court audio. So.
Sorry about that. That should be better, I think.
No, that should be right on. That sounds great to me.
Thanks for the notes.
Yeah. Yeah, but who hasn't? That's what I'm saying. Like, that's what I'm saying.
Who hasn't killed and eaten somebody? Who?
I think
who
he's
has
about talking about fucking a corpse. I think he's trying to be Jacob.
Oh, well, I mean, you know.
I mean... No comment. Don't admit your crimes on the internet. So.
It's technically a victimless crime.
Technically. Because they're not.
I mean, I think it's just referred to as vandalism legally, actually.
Is it really?
Yeah, because a dead body isn't really a person; it's property.
Right.
And so if you, it's vandalism if you violate property, basically. Now I don't know if it is legally classed as that exactly, but there's no real specific crime like a statute about necrophilia, just like there's no real statute about cannibalism. So,
Okay.
at least that I'm aware of.
Gotcha. Okay. That's interesting because I would think that both would have application, and it's interesting that they don't. So, abuse of a corpse. Well, abuse of a corpse is different than. Yeah.
Abuse of the corpse. That is. I believe it's jurisdictional. I don't think that that's across the board.
Okay.
That it's necessarily always called that or referred to that way. But then again, I'm not, I haven't studied this formally, so I could be wrong.
What's up, Gemstone Hip Hop? Yeah, I didn't, but most guys have had sex with, or at least one sexual experience where a lady just lays there and doesn't do anything. I think that, anyway.
Well, but she's still warm. I mean, there's a difference.
Even if she's not duct taped. Well, God, there's so many places I could go that I'm not going to right now. I didn't know he had sex with the corpse. It adds another layer of dimension. Yes, he had, I think there's penetration after he murdered him, so. I love you guys so much. You're awesome. All right.
Thank you very much, Mr. Kraus. Will it be Mr. Leach then that'll respond?
Yes, Your Honor. Thank you.
You're welcome.
I'm not going to go through the Vandervliet test. I know the court is certainly well aware of all of the various requirements, and just focus on a few of the things that we think are important to think about today. With regard to the Galloway case as cited by the defense, it wasn't ignored by the people. That case, as I'm sure the court has read, involved very different circumstances. That case involved the killing of 2 women, one of whom was killed, was a coworker of the defendant, knew him, had a long-standing relationship, and
I think it would have to.
Some voluntary contact with the defendant.
That's
in that case.
If I've ever heard it.
The second murder was a pure, he stalked a woman while she was jogging and killed her on that scene. The evidence offered by the prosecution in that case.
Mr. Leach.
Wait, before we get too deep. Chandler, so what can Shiawassee get charged with for having her sex with a corpse?
That's a good question, Barbara. So I know that they're trying to change that. Because I'm pretty sure that there were some sexual assault charges that they want downgraded. Now, I could be incorrect about this, but I believe they want it downgraded because he was dead after he was supposedly assaulted. But as far as, I mean, I suppose abuse of a corpse is now, a thing that but I mean, I guess the thing is, it's called abuse of a corpse, but it's not really like a very serious charge. I don't think that you get a lot for it. I mean, Shiawassee is going to be charged with murder. That's going to be the main thing. They can throw as many counts on there as they want. They don't necessarily have to charge her with everything, because she's probably going to get life in prison for the gruesome murder of the boyfriend. And it will have some factors there that are going to sort of enhance the sentence. So, I mean, the problem is they have to be able to prove that she had sex with a corpse. And, I mean, they can definitely prove, that she disposed of the corpse or mutilated the corpse. There are those charges. But I don't know, I haven't really studied the Shiawassee case that significantly. I just know that she cut him up and did sexual things with him. So, I mean, I have to look up the charges. It's a good question, Barbara. I'll have to get back to you.
Okay. Yeah, and, I mean, if it's just, a blanket of abuse of a corpse, then she theoretically did that by chopping him up, and it will probably be more of an enhancement than anything else, like you said. So, like, why waste the effort when I imagine she's gonna get murder 1, but
here we go. Yeah, we have first degree intentional homicide, mutilating a corpse, and 3rd degree sexual assaults. Now, I don't exactly know what 3rd degree sexual assault is in Florida. I'd have to look into that, because I've never seen that term.
Shit.
What would be a misdemeanor?
The 3rd degree sexual assault? I could.
No, I don't know if that's a misdemeanor. 3rd degree sexual assault. Let's see. Let's find out.
It is.
There are different degrees. In the second degree, it's a felony. Let me see. I'm gonna have to look into this some, further. I don't want to misspeak.
Yeah, no worries. No worries. Thanks, just curious. I'm a firm believer in throwing as much at them as possible in case they get off with the murder charge. Yeah, I can see that. But you can also make a bias from just stacking shit up that doesn't make sense or doesn't fit anything. Because then you get a jury and they're like, oh, well, they're not guilty on that one. So are they not guilty on that one or that one or that one? I can see
fair.
It rolling downhill. So.
Oh, I have an article. At issue is not only what investigators claim Shiawassee did with the body, but whether her victim was legally a person once he was dead. First, the defense argues the evidence that the state says shows sexual assault of the body is inconclusive, including laboratory testing and because of the dismemberment. Second, it says the prosecutor seemed to rely on statements Shiawassee made to investigators while she was under the influence of illegal drugs. And third, the defense contends the cited statutes for sexual assault don't apply because once the person is deceased, they are no longer a person as defined under the jury instructions in the statute. So there you go.
That's exactly what I'm saying.
Mm-hmm.
Dog Vomit. You're like, oh shit, they're just trying to railroad this lady, and then maybe not with Shiawassee because she's fucking insane and just about as bad as Mark, and she's gonna get it all. But yeah, I think it's a chance that you take. Maybe not a huge one, but I think it's definitely a chance that has the potential to be a bad one. Doing a grip kit on a body part. Yep. So
I'd rather not. I'd rather not imagine doing anything with a body part that is separated from the rest of the. Yeah, no, I don't think I could ever be a mortician or anything like that. I don't think I could hack it.
dead bodies creep me out.
But Taylor Shiawassee said that she could hack it, so she did.
She hacked it and then shoved it in
A bucket?
dark hallway.
I think a bucket.
I thought she never.
I think she put his head and his genitals in a bucket for his mom to find.
No shit.
Yep.
Wow.
Oh, you didn't know that?
No, I
How do you not know
haven't
this?
paid attention to Shiawassee. Like, I've heard of it, but I
Oh,
haven't.
it was Legal Vices who told me all about that. After one of our first streams, he was like, "Have you heard about Taylor Shiawassee?" And with glee, he went over all of the details, and I was like, "Oh my god, this is so horrifying!"
Gross.
Oh man.
Shit. That sucks. All right, I'm getting through this, at least this portion of it. We're not gonna finish today, but we're gonna try. So yeah, there's like 14 minutes left of this, 13. So.
But do you agree with Mr. Kraus that that the two prior acts did not result in a murder?
In our instance,
Yeah, in our case, yeah.
yes, we would certainly concede that.
Okay.
But the prosecution in the Galloway case had offered those similarities, and the similarities were that the women victims appeared similar in appearance. Both were killed, and there was talk of sexual assault or for a sexual purpose, although those acts weren't charged in either circumstance. As opposed to the current case, or the Latunski case where we're here, I guess I would start by suggesting that the method of operation and other things, other acts as covered by 404B, but not exclusive, certainly make the evidence relevant. However, some of the things that are important to note for the court where the behaviors were similar, first of all, both Mr. Palacios and Mr. Carlson felt the need to escape from Mr. Latunski's residence after being placed into a bondage type situation, which went beyond their comfort level. And they both fled the residence seeking the help of, in the case of Mr. Palacios, a neighbor, and ultimately the police, and of Mr. Carlson, ultimately the police as well. So they did have a level of fear based on Mr. Latunski exceeding their expectations of what was consensual. The method of operation, the pattern, lack of mistake also continue in other ways. Both Mr. Carlson and Mr. Palacios and Mr. Bacon all were transported to the defendant's residence by the defendant with no means of escape were they to become uncomfortable. Hence, Mr. Palacios and Mr. Carlson fleeing the residence. In the case of Mr. Palacios, in a kilt and no shirt. All three, Mr. Palacios was picked up in Lansing and driven to Mr. Latunski's residence. Mr. Carlson came from New York on a bus pass or bus ticket purchased by Mr. Latunski. He was ultimately picked up at the Greyhound station in Flint and transported to Mr. Latunski's residence.
See, there's your problem.
And in the case of Mr. Bacon, he met Mr. Latunski in the Schwartz Creek area, left his car, clothing, and cell phone, and was again transported to Mr. Latunski's residence without a means to leave, without being on foot. The level of fear experienced by both Mr. Latunski and Mr. Palacios, and unfortunately we can't speak or hear from Mr. Bacon as to his level of fear, but they both felt such a level of fear that they felt the need to flee the residence. Mr. Carlson also talks about an act in which I think he described as pig and butcher, which was him hanging in a manner very similar to how Mr. Bacon was found.
Oh, shit.
So I think that shows, again, a proper purpose under the 404B rule, which, as the court is well aware, is a rule of inclusion, not a rule of exclusion. Finally, with regard to the court talked about motive in its questioning of the defense. And even if the motive is uncontested, it doesn't eliminate all of the pattern, method of operation, lack of mistake evidence that will be presented through the testimony of Mr. Palacios and Mr. Carlson. And I guess as I think I said final, as a final point, those gentlemen would be subject to cross-examination as to the nature of their relationship and the changing of their stories. So I think for all of those reasons, and the fact that the communication, however it began, was conducted through various social media with all three of the individuals for which we are speaking, I would ask that the court, I guess, deny their motion. It was filed in a strange order in that the defense preemptively filed an objection to 404B, which was followed by our notice of 404B, and then our response and their reply, which is why I'm talking about the
I treat it as defense motion to exclude the 404B evidence.
So I would ask that that motion be denied.
All right, Mr. Leach, thank you. Mr. Krause, would you like last call on this issue?
Of different portions of it.
Just very
The
briefly,
whole
Your
thing
Honor, in
is
terms of
about
the
an hour
cross-examination of the two other
real
gentlemen,
time.
it just really
And
should not
we'll go
come to
through it
that,
all.
because
It's
once that
probably
bell
gonna
is
be next
rung,
week, though,
I just don't
when
think
we
it can
finish
be
up.
unrung in front of the jury. And I think that these other acts, again, are not relevant in terms of the crimes with which he is charged with in this case. But even if they were, the prejudice will just be too great. And we're mixing apples and oranges in a big way here, because on the one hand, we're talking about fear and a sexual practice of BDSM that had nothing to do with the murder and mutilation in this case. It's just too different. So we would ask that the motion be granted. Thank you, Your Honor.
Thank you, Mr. Krause. And of course, ready to rule. Defendant objects to the prosecutor's notice of intent to deduce other acts of evidence. That's under MRE 404 sub B. The people's notice indicates that they intend to produce evidence at trial relating to defendant's interaction with two other individuals. Based on the court's review of the material provided, it certainly appears to the court that defendant had a dating relationship with these two people. but the court doesn't know if the facts of the charged crime would support application of MCL 768.27B. So it'll begin its analysis with People v. Vandervliet, 444 Mich 52. That's at page 81 in 1993, Michigan Supreme Court. We know that the rule is one of inclusion rather than exclusion, and that there is no presumption that the other act's evidence should be excluded. The first prong of the test is whether the evidence is offered for a proper non-propensity purpose. One of the reasons articulated in the notice in the people's brief, the most compelling, is the use of a common scheme or system. The court reads the people's argument to be that the defendant committed multiple acts that are so similar that they have common features indicating a common design. The court takes that language from People v. Sabin, 463 Mich 43 at 2000 Michigan Supreme Court decision. The people argue that the defendant met the other act's witnesses on a social media site. It appears from the police reports that these were all the same social media site. Mr. Latunski befriended them. Over the course of that relationship, he's had these men over to his house on different occasions, of course, where they engaged in consensual activity, including bondage. Then, defendant purportedly exceeded the scope of the consent and subjected both of them to acts of bondage to which they did not agree. The people allege that the facts in this case followed the same pattern, with the difference that this case, of course, ended in a killing. Each of the other acts bears some other resemblance to the facts of this case, although distinct from one another. So there's simply no delicate way to say this, but the court understands that the charge of mutilation of a corpse alleged that the defendant mutilated the genitals of the decedent in this case. One of the other acts involved the defendant and the 404B witness engaging what the court can only call consensual genital torture. The other 404B witness describes sexual acts involving the witness hanging upside down.
Yeah, what's up?
The court reviewed a number of photographs relating to this case.
Oh, consensual genital torture. Yeah, it just took me a moment to process that. I actually have to go because I forgot I was going to be on this other stream with Nicholas, and I realized it's on my calendar earlier than I thought.
Oh, no worries. Like I said, I'm about to finish up here.
So let's leave it at consensual genital torture, and congratulations on 1,000 subscribers, everybody! Thank you so much. Thanks to everybody who subscribed tonight and who got you there. I'm so excited for you to get monetized. That's awesome.
Absolutely, and thanks for coming on. I always appreciate it and enjoy
Totally. It. Yeah, sorry I have to leave early. But I guess I'll be. I don't know if is this wait, is this the last one?
No, there's gonna be one more.
Okay.
Because we still have a bunch of shit to go over, but yeah.
All right.
One more.
Well, I look forward to that, and I'm sorry I have to leave, but I will see you all in the next one. Goodbye, everybody, and enjoy the remainder of, well, whatever happens with consensual genital torture, however they talk about that. That should be really interesting. I'm sorry I have to go right now. All right, bye, everybody.
All right, take care. All right, so that was Chandler, and like I said, we have about 4 minutes left, and then I am going to wrap it up for tonight. Go do some celebrating over in Discord. But yeah, so let's run out this last 4 minutes.
Earlier in the week, and notes that the decedent's body was apparently hanging upside down at the time that it was discovered by law enforcement. Similarly, a jury could conclude that the two encounters with the 404B witnesses were rehearsals for the commission of the charged crimes. Preparation is also a listed purpose for the admissibility under 404B. The court is persuaded that the people have met their burden with respect to the first prong of Vandervliet. The next prong is whether the evidence is relevant under MRE 402. The court struggled with this prong at length because the people's briefing on the issue seems largely conclusory. The brief seemed to argue that the existence of a common scheme is relevant to prove the existence of a common scheme. The court thinks that the existence of a common scheme is properly relevant to proving defendant's identity as the perpetrator of the charged crime.
Yeah, I keep forgetting, Sean, that you're relatively new here. Go back and check out these streams. They're the interrogation streams. He rehearsed with Blue Mountain oysters for eating testicles. He absolutely knew what the hell was about to happen here. So
unless the defendant concedes that he committed a homicide, the prosecutor must prove beyond a reasonable doubt that a crime occurred and that the defendant committed it. That puts his identity as perpetrator of the charged offense at issue. The fact that the people charged the defendant with open murder also necessarily means the jury will have to consider whether or not defendant premeditated the charged killing. Because the other act's evidence could be offered to show preparation, it would also be relevant to show premeditation.
you miss.
The third prong is whether the
100%
danger
of
of
the
undue
balls you don't
prejudice
eat.
substantially outweighs its probative value under MRE 403. The court finds that it does not. The evidence is not so shocking or inflammatory that the jury will be likely to convict defendant simply based on his interactions
No,
with the
if you haven't
404B
seen the
witnesses.
interrogation,
Defendant's
it's
argument
really
that their
worth it,
prejudicial
truly.
impact cannot be cured by cross-examination simply is not true. Defendant's motion identifies many avenues for cross-examination, such as the timing of the report to law enforcement or the fact that witnesses returned to defendant's house despite claiming that they were afraid of him. Those are all credibility factors that the jury can properly consider. And they're not so prejudicial that a jury is likely to disregard rational consideration of the charged offenses. The court also finds that submission of a limiting instruction will guide the jury in the proper use of other acts evidence. The standard other acts instruction informs the jury that it must find the other acts occurred before using those acts for their intended purposes. Thus, the jury will be on notice that it must find the 404B witnesses credible before considering the evidence they offer. The use of a limiting instruction satisfies the fourth prong of Vanderlee, so the court will order counsel to include that in their proposed stipulated jury instructions. Defendant's motion then to exclude the 404B evidence is denied. Mr. Kraus, could I ask you to prepare an order relevant to your motions and Mr. Kerner the same
Yeah,
to
I
yours?
didn't get that either.
Yes, sir.
All right, gentlemen, is there anything else the court can do for you today? Mr. Kraus.
No, Your Honor, thank you.
All right, well, it's very nice meeting you.
Nice meeting you, Your Honor. And thank you.
Yep, you're very welcome. Looking forward to seeing you next time.
Nothing further for people.
Thank
Hold
you.
on, hold on. Mr. Kraus and Mr. Kerner, Mr. Grant, can I ask the two of you to check in with the court administrator before you leave? She just has some administrative questions for you regarding the upcoming trial. If you got a minute, Mr. Kraus.
Absolutely, Your
All
Honor.
right, Ms. Lab is right here, and she'll take you back to her office if you don't mind.
That's fine.
All right. Well, if Mr. Kraus needs some distance, maybe Ms. Lab, you can take him in the jury room, court number 2, so he has some room.
All right. Well, that is it for the pre-trial. So he was all set to go to trial. He was ready to make it happen. And then he changed his mind. But yes. But you find lovely people. Hang on, I'm going to turn myself back up. So you find lovely people are going to have to wait for that next week. It's going to happen next week. We'll finish up with Mark next week. We'll finish all of the sentencing, the impact statements, the family statements, the plea, the trial, if it is, when it is. I don't know. I am so fucking excited about this right now. I'm gonna be 100% honest. I really wanted to go jump in Discord and just be able to talk to everybody and tell everybody thank you. So, plus, I need more content, so I got to string it out one more week, right? Right, yo? I really do appreciate nothing more. This is so damn humbling to finally get here. If you would have asked me when I started this journey if I would have ever got to this mark, I would have said, yeah, there's no way. But I found some great people, and I appreciate you all. All right, I'm going to stop being a soft douche, and yeah, I'm gonna go ahead and hit that outro. I thank you all, as always, for hanging out with me. We'll finish up Mark next week. Thanks, buddy. Thank you. And tomorrow will be a new category, new show. So look out for us tomorrow. And yeah, that's about all. That's about what we're. Yep. So thank you so much for joining us. Thank you to Brian again for this lovely outro music, wherever the hell it's at. And I will catch you all tomorrow, 8:30 Eastern. Have a great night. Bye-bye.